A support order or income withholding order from another state is registered here by sending the following documents to the tribunal here, with the exception of which one? A letter of transmittal sent here requesting registration and enforcement.
True.
3 copies included 1 certified of all orders to be registered.
False. It's 2 copies, at least 1 certified. Right?
Yes, and 3 copies of the petition.
The petition, right. Yes!
Yeah. So the support order, the income withholding order, and then the custody order in Article 5 are all 2 copies, 1 certified.
And the petition that New York sends to Oregon is 3 copies.
Yes. Okay. A sworn statement by the party seeking registration.
That the order has not been, like, vacated or modified or something?
Yes.
Okay.
The name, address, and social security number of the obligor.
True.
Yes.
Because I remember you were like, who wants to give their social security number?
I was just thinking that. I'm like, because nobody likes to do that anymore.
Right.
A description and location of obligor's property not exempt from execution.
This part, you're like, go look at Article 52.
Yeah, and I was like, yeah, well, good luck. Go look into CPLR for that one.
That's true.
Okay, yeah. So the only one that was wrong was the copies. Oh my God, I'm like losing my mind. All right.
I'm getting so tired today.
I know.
Ugh.
I can't. In which of the following proceedings must an attorney for the child be appointed if no other counsel is representing the minor? Article 3, JD?
Yes.
Article 7, PINS?
Yes.
Article 10, Child Protective?
Yeah.
Article 5, Paternity?
No.
No, it's only 3, 5, and 10. I mean...
3, 7, 10. 3, 7, 10.
Okay. Okay, next quiz. Let's see what it is. It's like on everything, so let's see what this one is. Oh my God, this is on the DRL and the RPAPL and rules. You want that
cool.
one?
Yeah, let's do it.
Okay. A notice of appearance is to be filed at the first appearance in court or within blank from retainer or appointment, whichever is sooner.
10 days.
Yes. There are blank terms of court, and each term is blank weeks long.
Oh, that it's 13 in a year and 4 weeks. Like,
I know. Exactly. A county clerk, chief clerk of Supreme Court, or county court shall refuse to accept for filing papers under which of the following circumstances? 1, the paper does not have an index number.
That's true.
2, the caption of the summons, complaint, petition, or judgment has et al. Instead of naming all the parties.
Summons,
that's true, right?
Petition, or yeah, that's true.
Yeah. Those are the only ones that have to have all the names listed.
It's like the answer and stuff could have just et al.
Okay. The paper is filed in the wrong court.
Yeah.
The paper is not signed in accordance with Rule 130-1.1 certification.
True.
The paper sought to be filed as an action subject to electronic filing.
I think that's enough information to make it wrong.
I know. Let's see the answer.
Because if it's a pro se party, then he's exempt.
I know, it doesn't say that.
All right, so what else do they got?
That's it. It's saying that they're all true.
Okay. Well, generally, yeah, but if it's a pro se party, all right.
Okay. Or I remember your video because you're like, or if the
Luddite, he can't fucking figure it out.
You were like, oh, if he's too stupid to figure it out.
Do you know what's sad? And that video has more views than any of my other videos, and it's horrible. It's so unedited. It's horrible.
And the one that you were doing, the rain, you were like walking around, you're like, fucking they want us to...
Oh my God, that's my second most viewed video. Like
4 fucking months.
Oh my God, yeah.
I was like,
I'm thinking about like how much effort it's gonna take to delete all these videos, and I'm like, you know what? I'm just gonna fucking leave them up. I don't care.
Shall be no fee for a RJI in any application to a court not filed in an action or proceeding or upon following matters with the exception of... Okay, there shall be no fee for an RJI in an application to a court not filed in an action or proceeding or upon the following matters with the exception of A, an Article 78 proceeding, a petition for sale or finance of religious non-for-profit property. Oh, I thought I lost you.
No, I'm here.
Okay. Application for a name change.
True.
Habeas corpus proceeding where the movement is institutionalized.
Definitely true.
Default judgment to the clerk under CPLR 3215.
False.
Ooh. I don't fucking know.
That's false.
That's false. That one does
you
have...
You gotta pay for that.
You have to pay for that?
Yeah.
No, it's saying that you have to pay for an Article 78 proceeding.
It's only Article 78 proceeding that you don't have to pay for when it's the jail credit thing.
So you do have to pay for that.
Generally, you have to pay for it, but then that means you don't have to pay for a default application?
A default judgment says no to the clerk under CPLR 3215.
I didn't know that.
I didn't know that either. I knew the other ones, the petition for the sale, whatever, and the name change and the habeas corpus.
Oh, I gotta go back and look at my video on this.
It's 202.6.
Yeah, I gotta go watch that video again. Because I don't remember that at all. I don't remember the 3215 thing at all.
Yeah, I don't either.
So we're pretty sure that the 3215 application to the clerk on a default is not listed in Rule 202.6. There's a bunch of items, but it is not one of them. So, yeah.
Okay. 5. A calendar that is for actions that have had a pretrial conference or where such conference was dispensed with by the court, but where the actions have not yet been transferred to a ready calendar is known as a... Yes, it's a reserve calendar.
Okay, reserve calendar, okay.
Okay. Notice of permanency hearing shall be made upon the respondent or foster parents caring for the child or pre-adopted parents by the petitioner not less than...
Shit, I don't know either.
Okay, the choices are 1 week, 14 days, 2 weeks, or 1 month.
I'm going to go with the 14 days.
Me too. We're right, 14 days.
Well, okay, well, that was because they made the choices easy, but I totally didn't know it.
I know.
All right, so what was that again?
The
pre-adopted parent thing?
Number set. Let me see where it came from. Oh, it's in a rule. It's a rule.
Oh, 205?
It's a 205 rule. Notice of permanency hearing shall be made upon the respondent or foster parents caring for the child or pre-adopted parent by the petitioner not less than 14 days.
Oh, I do have a video for this, but it's really old. So I probably haven't watched it in ages.
Oh my god. Okay, 8. The following civil cases are entitled to a preference in regard to the order with which cases are tried. And it's CPLR 32 something. An action brought by or against the state.
Absolutely.
An action where a preference is provided by statute.
True.
An action where the interest of justice will be provided by an early trial.
True.
An action upon the application of a party who has reached the age of 70.
Yes.
An action based on medical, dental, podiatric malpractice.
Yes.
An action to recover damages for personal injuries where the plaintiff is terminally ill and alleges such illness is a result of action by the defendant.
That's also true.
Yes. Okay. When no such preference exists, civil cases are tried in what order?
The note of issue is filed.
An owner or tenant within blank of a demised real property being used as a bawdy house. What the fuck is that?
A bawdy house? It's like a hoe house. That's what it is.
A bawdy house?
I think it's called a bawdy house.
Oh, so it's like the Bunny Ranch in Vegas or something?
Yeah, but it's like a cheap...
May serve personally upon the owner or landlord of such premises written notice requiring the owner or landlord to make application to remove the persons occupying the premise. An owner or tenant within blank of a demised real property. 50 feet.
200 feet?
You know what? That's where I was going with 200 feet. So let's see if that's right. Yes, 200 feet.
200 feet.
Yes. Okay. A notice of petition for the recovery of real property may be issued only by which of the following? An attorney, a judge, or a clerk of the court.
The attorney, the judge, or the clerk.
The sheriff or other person shall give blank hours notice in writing prior to eviction, and the eviction of the warrant shall take place between blank.
Okay, it's 72 hours, not including Saturday, Sunday, and holidays, and sunrise and sunset.
Yes, perfect. It is not required for a defendant to enter a plea to a misdemeanor complaint. Misdemeanor complaints must be replaced by an information for the prosecution of the matter to take place. Generally, supplementing a complaint with blank satisfies the requirements and the complaint is deemed to be converted to an information.
Supporting deposition?
Do you want to do more? Because I have some for the DRL and VTL and mental health, Article 10.
Oh, yeah, let's do Article 10 and test my knowledge a little bit.
Let me get to the question. Hold on. Okay. What the fuck? A congenital or acquired condition, disease, or disorder that affects the emotional, cognitive, or volitional capacity of a person in a manner that predisposes him or her to the commission of conduct constituting a sex offense, and that results in that person having serious difficulty in controlling such conduct, is the definition of
a mental abnormality.
Oh my God, is that right? Yes! A sex offender requiring civil management means a detained sex offender who suffers from a mental abnormality. A sex offender requiring civil management can, as determined by procedures set forth in the Mental Health Law, Article 10,
it's a sex offender requiring intensive supervision, or a sex offender requiring confinement in a treatment place or something.
Yes, and there's two more.
Oh, there is?
Yeah.
What are the other two?
A sexual deviant requiring probationary oversight.
Oh, I didn't get to that yet, I guess.
And an individual convicted of an offense within Penal Law 130 requiring treatment in a form to be determined by the court.
Oh, okay.
And it's a sex offender requiring strict and intensive supervision.
That's the one I was thinking of, the strict and intensive supervision.
And the other one is the sex offender requiring confinement.
Yeah.
Oh my God, I'm so wrong. All right, let me redo the question because you were right. It was only 1 and 2.
That's okay, thank God, because I was like, what the fuck? My whole video's wrong.
Sorry.
It's okay. All right, so just to be clear, it's the only two types. There's the detained sex offender with a mental abnormality, and he either needs intensive supervision or confinement in like a secure hospital or something.
Yes.
Okay.
Yes. Okay. A case review panel for Article 10 Mental Health Law proceeding consists of at least blank members, any blank of whom may sit as a team to review a particular case. I'm wrong. I don't know what the fuck I was thinking. 15 and 3.
Okay, so the 3 I remember, but the 15, I don't think I did the video on this part yet, so that's probably why I don't know it. But okay, 15 and 3. But
okay.
3 of them have to make the determination to notify the Attorney General.
Yes. Okay. I read like some of this because I have notes on it, but
okay.
Okay. Within blank days after the sex offender civil management petition is filed, or within such longer period as to which the respondent may consent, the Supreme Court or County Court before which the petition is pending shall conduct a hearing without a jury to determine whether there is probable cause to believe that the respondent is a sex offender requiring civil management.
Now, I'm going to get this wrong probably because there's a 30 days and a 72 hours. I don't remember where they go. So this one I'm going to guess 72 hours.
No.
Is it 30 days?
Yeah.
All right, so that's all right. At least I remembered one was 30 days and one. Oh, the one that's 72 hours is when he was due to get out. And basically the Attorney General like sat on it, or they didn't do anything yet, and now he's supposed to get out. Then they have to do it within 72 hours.
Okay. We'll just finish it. It's the last one of the mental health law.
All right.
Okay, which of the following statements are true regarding a trial for sex offender civil management? Okay. A, within 30 days after the court determines that there is probable cause to believe that the respondent is a sex offender, the court shall conduct a jury trial to determine whether the respondent is a detained sex offender who suffered from a mental abnormality.
Okay. I don't know that time rule is correct. All right, so 60 days to have the jury trial.
Yeah. Okay. B, the provisions of Article 41 of the Civil Practice Law and Rules shall apply to the formation and conduct of jury trial under this section, except that the provisions of the Criminal Procedure Law shall govern to the extent that the provisions of Article 41 of the Civil Practice Law and Rules are inconsistent.
That's true.
Yes.
And then it's 12 jurors and they get 10 challenges and 2 for each alternate.
Yes, I read that somewhere. I guess that's from here. Okay, next. Each side shall have 10 peremptory challenges for the regular jurors and 1 for each alternate juror to be selected.
That's false. It's 2 for each alternate.
Yes. And D, the jury or the court, if a jury trial is waived, shall determine by clear and convincing evidence whether the respondent is a detained sex offender who suffers a mental abnormality. The burden of proof shall be on the Attorney General. A determination, if made by the jury, must be by 5 out of 6 jurors.
That's totally false. It has to be unanimous and there's 12 jurors.
Yeah. And the burden is
on the Attorney General. Convincing.
Yes. Okay, good. All right. And that's all I got for the mental health shit. Okay. According to the domestic relations law, to register a child's custody determination in this state from another state, this state must be sent 1, a letter or document requesting registration.
Yes.
Yes. 2 copies, 1 certified of the order to be registered with a statement that it has not been modified.
Yep.
And the name and address of party seeking registration and the parent who has custody. All of the above.
I think it's all of the above, too. It's definitely the first 3.
A hearing to contest validity of a child's custody determination that was registered in the state from another state needs to be requested within how many days of receiving notice?
20 days.
Yeah. All right, I think I'm good with the 20 days. Okay. All right, let's see what else I got here.
I got a pop-up question for you.
Oh,
this is Article 3, Juvenile Delinquency. Blank means the temporary care and maintenance of children away from their homes.
Is that foster care?
Detention.
Fuck! Oh my god, I can't. I'm feeling so horrible tonight. That's great.
Me too. After that Article 7 test that I've done like 20 times now.
I couldn't even get detention right. Wait, ask me something else. I'm like fucking.
Ask you something else.
I want to cry.
Don't cry. The detention of a child under blank years of age in a secure detention facility shall not be directed under Article 3.
Is it under 10 or 11?
Yes, 10.
Okay. Oh my god.
All right. That one's an easy one. Immediately notify the parent. Okay. Oh my god, I hate this question. This is a pre-petition in Article 3. If the crime alleged to have been committed by the child is a designated felony, the return date of the appearance ticket shall be no later than blank.
Oh shit, is this the one that was longer? No. Is it 4 court days or something?
It's 72 hours.
I was gonna say 72 hours, but then
always go with your first instinct on the test, you know?
I was gonna say 72 hours, but there's something with 4 court, but there's something...
that's I know what that is. I'll ask you that question.
If they don't file a petition within 4 days and the guy's in detention, he has to be released?
It's either 3 days of the conclusion of the initial appearance or 4 days following the filing of the petition, whichever is first, when he's in detention.
Okay.
Okay, back to pre-petition. If the crime alleged is not a designated felony and the person's in detention, the return date shall be no later than blank.
72 hours?
It's the next day family court's in session.
Oh my god, I fucking hate myself right now.
Okay, a copy of a family court appearance ticket shall be forwarded by the issuing person or agency to blank. And there's 4 of them.
The complainant.
Yep.
The respondent.
Yep.
The, is it the parent?
Yes.
And probation?
Yes! You got them all!
Fuck!
Wow.
But
Oh my god.
I can't get the fucking time rolls. Great.
This is another JD question. A petition shall be, and I'll give you choices. A petition shall be blank in accordance with the CPLR. 1 subscribed, 2 acknowledged, 3 verified.
Verified.
Yep.
I was thinking verified when you said it.
At the conclusion of the dispositional hearing, the court may, upon motion of respondent or sua sponte, and with consent of blank, substitute a finding that the person is a PINS. So who has to consent?
The presentment agency, the complainant?
No, it's only the respondent. Because the key to this question is at the conclusion of the dispositional hearing.
Okay, so it's after.
So after the dispositional hearing, it's only the respondent has to consent. Summons in Article 3 may be signed by who? There's 2 of them.
Oh, the clerk or a judge?
Yes. An order dismissing a petition as defective may be issued upon motion of who? And there's 2 of them.
The court or the respondent?
Yep.
Ugh.
A motion to dismiss a JD petition shall be served upon opposing party not less than blank days prior to the return date.
8?
Yep.
Oh my god.
This is 8 and 2, this one.
2.
Upon issuing a warrant due to respondent's failure to appear for a scheduled court date, the court shall adjourn the matter to a date certain within blank days for a report on the efforts made to secure the respondent's appearance.
Oh shit. Is it 60 days?
It's 30 days.
Again, I was thinking 30 days my first, and then I said 60.
It happens all the time. You have to go with the first thing, and I'm going to explain to you the psychology of that. Because you think you're guessing, but you're actually not guessing. That voice, that's your subconscious, that is usually correct. It's like something like 7 out of 10 times that's correct. Your first answer is correct. So, okay. All right, next. Here is a civil question for you.
Oh, great.
This is 2302. Unless the court orders otherwise, a motion for a subpoena ducis tecum for an original record when a copy is admissible in evidence should be made on blank day's notice.
3? 20, what day? 24 hours?
Hold on. Let me look at the answer before I tell you.
I don't know.
I just want to make sure I'm looking at the right answer. Because I thought it was something else, but I definitely could be wrong. Okay, so that was 3. Yeah, it's 1 day.
1 day.
So to compel an original and this is a motion because a court has to give you the subpoena. When a copy is acceptable to be submitted, you want the original, you have to get a court order for that.
For 1 day.
And the motion is made on 1 day notice.
But if it's for records or something, like in the medical to a hospital, is that the 3 days?
That's the 3 days.
Okay, because I remember something was 1 and something was 3. I couldn't remember which one.
3042. If a party upon whom a demand for a bill of particulars is unwilling to give such particulars, they may move to vacate or modify the notice within blank after receipt thereof.
Or 30. It's great. I want to fucking cry. I'm going to fail this test.
No, you're not. I'm asking you, like, really hard questions.
Oh, my God.
I got all those ones in Article 7 wrong, too. Oh, a certificate of merit is required when commencing an action for...
medical, dental, podiatric?
Yes.
You know how I remember that? From Angela.
Really?
Yes, because she did that stupid boob thing.
Yeah.
Well, if I have my botched boobs, they got a certificate.
In a civil action, the judge shall only be present at the examination of the jurors if he doesn't want to, when
when they ask him to be there.
Yep. Application of any party. A party may challenge blank jurors for cause.
Unlimited.
Yes.
I've done so many trials in the last fucking 2 weeks, I wouldn't kill myself.
Summary judgment may not be granted in favor of the non-moving party in a blank action.
In a... Oh, shit. Fuck, I know this.
Let's skip that one and we'll go back to it.
Oh, God.
True or false? When a party is in default for failure to appear, he shall not be entitled to a discovery notice.
Wait, when what?
True or false? A party is in default for failure to appear. So he didn't file an answer, didn't file a notice of appearance, didn't do anything. He shall not be entitled to discovery notices.
Oh, I don't know. Is that true?
It's true. In general, an action to annul a marriage on the ground of fraud must be commenced within
3 years.
Yes.
Oh, the videos really work.
They really work. Like, I hate, like, it's like, I've been number 1 on my one test, number 2 on my 2 tests, and it's like, I just fucking made videos. Okay. In general, if the note of issue is filed without a request for a preference, any other party entitled to a preference should make his motion for a preference within blank days after the filing of the note of issue.
Oh, is this 10 days?
Yes!
Oh my God, I can't believe I remembered that.
That was on my 2011 videos too.
Oh shit.
But mostly I don't remember those videos. I remember that my 2007 videos were the best ones I ever had. Because I had 7 months to fucking make them.
That's what I'm saying. This shit is like crazy now.
True or false, any action except matrimonial may be commenced by filing with the court a submission of the controversy acknowledged by all parties in the form required to entitle a deed to be recorded.
What? I don't even know that.
Okay, let me read it again. This is a true or false. Any action except matrimonial may be commenced by filing with the court a submission of the controversy acknowledged by all the parties in the form required to entitle a deed to be recorded. And this is called the New York Simplified Procedure.
True.
True.
Okay.
Okay. This is a very hard question because it hasn't been, I don't think it was on your last test, so it might be really hard. If the defendant, after having raised lack of personal jurisdiction as a defense in his answer, waives such defense if he does not move for judgment on that ground within blank.
60 days?
Yes. Because I gave you the answer, but whatever.
I know. I'm like, 60 days.
All right, and the 3215 question is 1 year. I don't think I read it correctly. This is if the plaintiff fails to take the proceeding for entry of judgment within 1 year after a default, the court shall not enter judgment but dismiss the complaint as abandoned without costs. On its own initiative or with a... But I think I read that as the defendant, so I screwed up the question.
Well, I just remember 3215 because we had a calendar when I worked in civil, and we used to like.
Yeah, the 3215 calendar. You had to send them by certified mail.
Yes, and then there was a 3216 calendar
and
too.
Let me ask you the other 1 year thing. This is in 3404, so now we have the case on a trial calendar. A case in a superior court marked off or struck from the calendar unanswered on a clerk's calendar call and not restored within 1 year thereafter shall be deemed abandoned and shall or may be dismissed without cause for neglect to prosecute.
Shall.
Yeah. The clerk shall make an appropriate entry without the necessity of an order. Let me go back to the other question where you didn't know the answer.
Okay.
Action, but not a blank action. The court can render judgment in favor of the non-moving party. So what's the exception to that?
Matrimonial.
Yes. So when I asked it like that, you got it.
Yeah.
But when I asked it the other way, you didn't get it. So
yeah.
I should find it the other way. Okay, here's 3025 sub B. Any motion to amend or supplement pleadings shall be accompanied by the proposed or amended pleadings blank to the pleadings.
What?
It's showing the changes.
I don't like that question.
Yeah, that was a weird one. Failure to comply with subpoena issued by a blank is punishable as contempt of court. By a judge, clerk, or attorney as officer of the court. That you got right the other way, but let me just say it this way. Summary judgment may not be granted in favor of the non-moving party in a blank action.
Oh, in a matrimonial action.
Yeah.
Okay.
An action against a sheriff, constable, or other officer for the non-payment of money collected on execution must be commenced within...
Oh,
Angela's video?
3 years?
Yeah. For the purpose of Article 3, juvenile delinquency, the word officer means what?
Oh, fucking... I need to go over everything in family court.
It's police or peace officer.
I need to do family court, obviously. Obviously.
Right, what else do I have here? Oh, you know what? I should ask you some on mental hygiene law, Article 9.
I'm telling you, they're crazy. These articles, I don't understand. Like, how are we
Thank
supposed
God
to...
Jackie's doing that one.
How are we supposed to remember all this shit?
And any town or city clerk who knowingly issues a marriage license to a person who is under the age of 17 shall be guilty of a blank.
Misdemeanor?
Yeah.
And fined $100, right?
Oh, it doesn't say that, but I'll go with it.
Oh, okay.
And they're fined $100?
If they do it, yeah.
Oh, I didn't know that.
Yeah, it was something like that, I read.
Okay. Mental hygiene law 9.03. The section of the mental hygiene law under which a patient is admitted or under which any charge of legal status is subsequently affected shall be stated in the patient's blank.
Admission papers.
I don't know. I think it is.
I said it like so, like admission papers.
I think you're right.
What
Yeah,
is
you're
it?
right.
I am? Holy shit.
Mental hygiene law 9.01. Qualified psychiatrist means a physician licensed to practice medicine in New York State who, 1, is diplomat of American Board of Psychiatry and Neurology or is eligible to be certified by that board, or B, is certified by American blank Board of Neurology and Psychiatry.
Oh, the American, oh, fuck, I know this. I just read it. Shit, I don't know, just tell me. Hello?
Yeah?
Just say it.
Do you have something that, like, popped in your head or no?
It's something like, fucking, that first thing, like, that you said. American, oh my god, something. Fuck, I can't believe I can't think of it right now.
Alright, we'll come back to it.
Alright.
A certificate, as required by this article, must show that the person is mentally ill and shall be based upon an examination of a person alleged to be mentally ill within blank days prior to date of admission.
Oh my God, there's so many goddamn time rules.
Wait, 3.
I remember
It's
writing
10
5
days.
days.
10 days.
Fucking 10 days.
All right, let me ask you the other one. It's certified by the American Blank Board of Neurology and Psychiatry, or is eligible to be certified by that board. Osteopathic.
Oh shit, that's right. Okay. And do you know what? When I was reading that, it's the same definitions are in Article 730.
Really?
There's a couple that are the same.
Osteopathic?
I have it right here. I'll show you. There was a couple that were the same. So I'm comparing. I'm like, oh, this sounds familiar. So I went to 730.
All right, let me ask you this one. The director of any hospital may receive as a voluntary patient any person over the age of blank or over in need of care and treatment who voluntarily makes written application. And I never, ever would have guessed this right.
Is it 16?
Yes! I never would have guessed that.
Fuck. Oh my God. I don't fucking know.
Okay, let me just see what the answer to number 4 is. Okay, now this one says, when any person under the age of blank years is admitted to or converted from one admission status to another, notice shall be given to Mental Hygiene Legal Service within 3 days and shall specify the age and admission procedure applicable to such person.
Is this one 14?
This one is 18.
Oh my God. Again, I was going to say 18, but then you said it's right the age. And I was like, oh, maybe it's younger.
Okay. This is a true or false. It says a patient admitted informally shall be free to leave the hospital at any time after admission.
True?
It is true. Okay, true or false. The voluntary or informal admission of a patient must be reviewed at least every 12 months.
All right, true. It's a year.
Oh my God. All right, let's go back to civil. I can't even.
I can't. I'm doing this shit. I'm getting it wrong.
Okay. When a subpoena duce tecum is served upon a hospital, requiring records relating to the condition or treatment of a patient, such subpoena shall be served at least blank before the time fixed for the production of the records unless otherwise ordered by the court.
3 days?
3 days. Yes, it's 3 days. I fucking know it's 3 days. I don't know why I feel like I have to check the answer key for everything.
Oh my God. I feel like this is the only shit that I know and this and criminal, and then everything else I'm fucking stuck.
Oh wait, I have a criminal question.
Okay. Unless it's like in the 500s or 440, because I hate those.
Yeah, me too. I hate those too. Here we go. Oh my God, I love these questions. Which, if any of the following, is not an accusatory instrument?
Oh my God, I hope I don't get this wrong.
Indictment, misdemeanor complaint, appearance ticket, or superior court information?
Appearance ticket.
Yes.
Oh my
God. This one says, verdict means the blank by a jury in the case of a jury trial.
Decision.
It's an announcement.
Oh, fucking announcement. Whatever. I seriously have done so many jury trials in the last 2 weeks. I'm like, I'm done with jury trials.
In the case of a defendant charged with a misdemeanor punishable by not more than 3 months and no other offenses, a motion to dismiss must be granted when the people are not ready for trial within blank.
60 days? Wait. 6 months, 90. Wait. Oh my God. 6 months, 90, 60, 30.
60 days.
Right? 60 days, yeah. Okay.
A prosecution for a misdemeanor must be commenced within blank.
2 years?
Yep. A prosecution for a petty offense must be commenced within
1 year?
When the defendant has been committed to the custody of the sheriff, he must be released on bail when the people are not ready for trial within blank, where the highest offense is a violation and none is a crime.
15 days.
I think it's 5 days.
Oh, that's what I meant. 5.